Hi, I'm Shaye Larkin and thank you for visiting. If you've watched my other videos, then you know I'm a bankruptcy attorney here in San Francisco, and in this video I'm going to talk about the automatic stay. The automatic stay is what protects you from your creditors when you file bankruptcy. The terms of the automatic stay are found in a lengthy section, Section 362 of the Bankruptcy Code. It discusses what it applies to and what it doesn't apply to, and it goes on for pages and pages. So I'm not going to discuss everything. I'm just the main bits and pieces that I think might apply to you. If you want to know everything about the automatic stay, visit Section 362 of the Bankruptcy Code, which is found in Title 11 of the United States Code. So if you've not filed bankruptcy in the past 12 months, then your automatic stay is going to go into effect on the day that you file bankruptcy, at the moment that you file bankruptcy. Now, do your creditors know about it right away? No, they don't, because it's probably going to be about 3 or 4 days before the court sends out the notice to all the creditors. But you might, in some situations, want to give your creditors notice before that. Maybe your wages are about to be garnished, so you want to fax or email the creditor the notice of your bankruptcy filing right away, plus notify your payroll department because they're involved in the wage garnishment. As soon as you file bankruptcy, you can print out what's called the notice of bankruptcy case filing. It's the formal notice from the court that says this person filed bankruptcy at this time. So if your house is about to be foreclosed on, then you absolutely need to fax in that notice of bankruptcy case filing to the trustee who's conducting the foreclosure sale. So there's things that you might need to do right away to make sure your creditors know and stop this type of urgent collective action. If you don't have anything urgent going on, then you can just wait for the court to mail out the notices to everyone, but make sure you included the proper address for your creditors in your bankruptcy. And there's a rule about that. You're supposed to use the address in the last 2 most recent notices that you received from your creditors, but that's not always accurate. Some of my clients haven't heard from their creditors in years. You can't go wrong by using the corporate headquarters address, but it might not get to the right people, so they're still contacting you. You can also use the payment address or the customer service address from their website, so that would be up to date if you go right to their website. So that's the usual situation. A person hasn't filed bankruptcy within the past 12 months, so their automatic stay goes into effect as soon as they file bankruptcy. If you have filed one other case in the past year, then your automatic stay goes into effect when you file bankruptcy, but it expires after 30 days. And you have to file a motion with the court to extend it. And your motion has to explain why you needed to file another case. If you watched my video about the difference between Chapter 7 and Chapter 13 bankruptcy, I talk about something called Chapter 20. In that situation, we file a Chapter 7 bankruptcy and then a Chapter 13 right after. So in the second bankruptcy, the Chapter 13, we would need to file one of those motions to extend the automatic stay, and we would need to explain to the court why we were filing the second bankruptcy. Maybe we wanted to do a lien strip that we couldn't accomplish in the Chapter 7. We got rid of all the debt in the Chapter 7, but we wanted to file Chapter 13 to get rid of the second mortgage lien. So we explain all that in the second bankruptcy so that the court will extend the automatic stay beyond 30 days. Maybe my client doesn't want the mortgage lender to foreclose on the house. That's why it's very important. So in your situation, if you have filed one other bankruptcy, it could be because maybe in the first bankruptcy you didn't have an attorney, so you didn't know to file certain documents, and ultimately the case got dismissed. But you learned from that, and this time you have a great attorney, but it's your second bankruptcy in 1 year, so your attorney, or you, if you're representing yourself, would file that motion to extend the automatic stay. Now, if for some reason you filed more than one bankruptcy in the past 12 months, then the rule is far stricter. You would have more explaining to do. The automatic stay does not go into effect on the day you file your bankruptcy. You have to file a motion to impose the automatic stay, and you have to explain why it is that you filed 2 other bankruptcies or more in the past 12 months. Maybe with the first bankruptcy you got sick and you couldn't follow through. The second bankruptcy, you didn't have an attorney, didn't understand all the requirements, so it got dismissed. Now you have an attorney, so maybe you have really good reasons why you filed the other 2 cases, and you just need to explain that in the motion. And these motions, whether it be to extend the automatic stay or impose the automatic stay, they're what we call same-day motions, because there isn't time to waste here. So these motions need to be filed on the same day that you file your bankruptcy. Now, the automatic stay applies to most creditors, but not all creditors, and there's a long list of situations in Section 362, situations where the automatic stay does not apply, and I'll give you some examples. It doesn't apply in paternity suits, it doesn't apply in divorce cases, it doesn't apply in criminal proceedings, it doesn't apply in spousal support actions, and there's a bunch of other ones. So always consult with an attorney before you file bankruptcy, because this is not something that you want to be surprised by when you file bankruptcy. All right, so those are the basics with regard to the automatic stay. It doesn't apply in every situation. Sometimes it doesn't go into effect if there's been prior bankruptcy cases filed. But maybe your situation is such that you're not going to have these issues, and it will go into effect when you file your bankruptcy. Now, if the creditor violates the automatic stay, you should send them a cease and desist letter right away. And if they continue, like some payday lenders are not located here in the United States, and they don't know these rules, and they might keep hounding you. It's kind of hard to sue them, but it does give rise to a cause of action against the creditor who is continuing to contact you, and there are huge penalties that get awarded against these creditors. You know, sometimes there's cases where the mortgage lender continued to foreclose on the house even though it knew about the bankruptcy case. And there's, I don't want to say hell, I guess I could say hell, you're all adults. There's hell to pay when you do things like that. So yeah, see an attorney, find out what your specific situation is, and if there's any automatic stay issues with respect to your bankruptcy, and watch my other videos. Have a good day.